This is in brief the law concerning Indian forests, a law that was made during the British period and continues to operate even long after our independence. And this is the law, the primary law concerning the forest. In the year 1980, the government of India came up with another law, the Forest Conservation Act. Forest was a subject when India became independent as a state subject. That means states could only make law. And since there was already a central law earlier, the same was adopted and applied in all the states. But states had the power of making their own law, and even now we have the central act and the state acts in many of the states that we have in India. But by and large, the states' laws are aligned to the central law. In the year 1976, the Constitution was amended. It's called the 42nd Amendment to the Constitution. The subject forest was moved from the state list to the concurrent list. And so, by moving the subject from the state list to the concurrent list, the effect was the center also can make law, the state can also make a law. But if there is a conflict between the two, the central law will prevail. That means it's a tendency of centralization which makes the center to take over the administration or any kind of a control over a particular subject which was earlier under the state list but which was later moved to the central one or the concurrent one. But that's not the real reason. The real reason was that over a period of a couple of decades, it was noticed that the forest cover in India was coming down at an alarming rate, mainly because of the fact that the forest being under the exclusive management and control of the state did not regulate human activities, and many a time for various developmental activities, they diverted forest land. With the result, the forest area shrank. It was an alarming thing because internationally and scientifically, it is a well established thing that one third of the land area needed to come within the forest for a very healthy living. And that was not followed in India at all. A very healthy forest cover that was in existence before our independence became less than 18% of the total land area in India over a period of 2 to 2.5 decades of our independent existence and governance. And so the center thought enough is enough, that henceforth, if you want to divert the forest land for a purpose other than for forestry, you have to come to us. And we look into the pros and cons before we give either permission, reject permission, and you have to act according to our dictate. And this is according to the Forest Conservation Act. So it is the power of the central government of de-reservation of any forest area and use of forest land for a non-forest purpose by that particular state. This can only be done with the prior approval of the central government. And so, if the state want to lease, assign forest land to any private entity, that can only be done with the prior approval of the center. Clearing of trees that have grown naturally in the forest area, free for reforestation purpose also, can only be done with prior approval of the central government. So the center is taking charge and is control over the forest area mainly with conservation objective. Conservation was a casualty of the wild, and we want to repair that and reclaim the lost forest land. And for that purpose, we at the center, we would exercise greater vigilance, greater control, and come up with a rationale as to how and when and under what circumstances the forest land could be put to use for a non-forest purpose. A very small enactment of only 6 sections Section 2 is the primary section which I explained now. Section 3 provides for an advisory committee to advise the center in granting approvals under Section 2 and on matters concerning forest conservation. The government departments and authorities are brought within the purview of this law in terms of penal sanctions, that it is not just a private party who can be held guilty of violation of this law. Even governments, the heads of departments, can be held liable if they do not conform to this. This is the primary development that has occurred after our independence and long after our independence through this particular development of making this law called the Forest Conservation Act in 1980 by the Government of India. A small enactment of 6 sections and then later 2 other provisions were added to give a little bit of a teeth to this law, the Forest Conservation Act. The question is, how does this law work? A small enactment with so much of impact in terms of the center exercising control over that, and how does it pan out? Between 1980 and 1993, there was hardly any evidence that is available to show that the center did exercise its authority over this forest land as to reduce the adverse impact of the indiscriminate state action of managing the forest, resulting in great reduction in the forest cover. And this subject and the importance of the forest conservation came to its limelight through a case law. And it is very important that we very briefly discuss this particular case to really understand the implications, the import, and the impact of the working of this law, and also, in a way, a general critique of the working of the entire forest law. The case is T.N. Godavarman Tirumalpad versus Union of India. A case that started in the year 1993. Even to this day, that's very interesting. The case is not closed. It's still alive, but several orders were made. It's a landmark case. There is no parallel to this particular case, which runs to for nearly 3 decades as of now, which has involved more than, as of now, 120 odd sittings of the Supreme Court and over 40 to 45 orders passed by the Supreme Court. In the entire history of judicial interventions at the highest level, Supreme Court level, there is no other case comparable to this, both in terms of time and in terms of the orders that were passed by the court, having such a kind of a lasting impact on forest governance, forest management, use of forest area, and things like that. Not even constitutional important cases like Golaknath or Keshwanand Bharati have occupied so much of time of the court of law, and we shall presently see why it is significant and what it actually has delivered. In terms of the facts, very briefly, Mr. Godavarman, a landlord, having had vast areas of land inherited from his ancestors, a portion of that land, which was a forest land, which was taken over by the government under land reforms. One fine morning, this gentleman finds that forest area, which was taken over from him, saw a lot of activities. To cut a long story short, he observed the trees were being cut there, and when inquired, nobody was giving him a proper answer, as though giving him the impression, mind your business. It is something that the government is doing. Who is there to question the government or anything like that? And he felt a little offended for the simple reason a forest land that was nurtured and developed for decades by his ancestors has gone into the hands of the government with a hope and expectation that this forest cover would be conserved and protected, and here the forest land is being degraded. He just did not go away. The moment the forest authority said that it is a policy decision that has been taken and they are only implementing the same and they cannot be questioned or anything like that, he brings in a writ action in the highest court of law, in the Supreme Court of India, and that triggers a major inquiry by the highest court of law. The court first looks into this problem and it starts with a few preliminary questions on that, and suddenly it discovers that not only in this particular instance, enough justifications and reasonings are not there when the states do act with regard to the forest area in diverting the forest land for various non-forest purposes. They ask about the relevant law which would govern this, and Forest Conservation Act was mentioned, and whether those regulations that were actually laid down are conformed to or not. The forest authorities are not able to give a clear, cogent answer to convince the court. So the court suddenly takes upon, not just out of curiosity, but out of great concern, that look, you have such forest land that is being managed by the state, and the state agencies are not able to answer the question as to how the forests are being managed, how decisions are made with regard to the forest, retention of the forest as a forest area, development of the forest area, conservation of it, and diversion of forest land for non-forest purpose. And so the court probes into every of these aspects and finds that it is a very unsatisfactory state of affairs of forest management by the state. The court directs that all cases concerning the forest conservation of the Godavarman kind can be clubbed together, all of them, in different courts of law, in high courts, in different states, be pulled together and brought as one single action. And that's why this is called as the forest conservation case. And the highest court would consider this. As was mentioned, more than 120 orders, 120 sittings of the court, and over 40 orders were passed by the court. What are the orders? One of the orders, just to give a few examples, one of the orders passed by the court was with regard to the definition of the expression forest. We have already seen forests are not defined anywhere in this law. You have different categories of forest. Private forest, government forest. You have district forest, you have reserve forest. You have village forest, you have protected forest. But what is a forest? No definition has been given. Of course, the objective of the lawmaker was to use anything as a forest cover to exercise its control through a declaration and a notification. But the court said that there has to have a clear understanding, a clear perception as to what a forest is. So it goes by the dictionary meaning of the forest and then looks for the purpose for which forests are created. Remember the economic, the ecological, social, and human rights dimensions of it. For these purposes, for these objectives, forests are created, and so we will declare that as a forest. With all those expressions that are used in various government records of any kind is a forest. Anything that is declared as a forest under the definition that has been given in dictionary meaning will follow it. But it should have the purpose that forests are distinctive ecosystems which are meant for serving all those objectives that we have discussed earlier, and that would be ranked as a forest. That was the meaning that the court gave, which is actually adding to the legislative law a judicial gloss and a judicial supply of omissions. The second thing that the court did was it found that there were several industries that were there within the forest area, forest based industries, which were not following the conservation ethics. There were violations, and the authorities were not paying much attention to those violations. And this was also another cause for forest destruction. So, what the court did was that till you sort this out, streamline it, rationalize the entire process of what gets into the forest industries, how it gets in, with what kind of due authorizations, and how it is being put to application and what product comes out of it. Till then, you freeze all wood based industries. It banned felling of timber. It wanted a clear inventory of the forest. Because one of the questions that the court asked was to the authorities, including the Environment Ministry, how much of area of land comes under the forest cover? The government took a lot of time and still was not able to come up with a very clear, exact, in terms of square meters or square miles of the area on land coming under the forest jurisdiction. And so the court said that there has been a clear administrative lapse, there has been a clear policy lapse, there has been a clear implementational failure. And so we are going to actually ban timber felling till you take an inventory of whatever timber that is there in the forest area. The timber movement from any of the 7 northeastern states, because these 7 northeastern Indian states were actually guilty of poor management of timber movement, leading to destruction of large areas of forest land. A special committee was constituted to oversee, monitor this particular activity. And even in deciding on mining leases within the forest area, there were several discrepancies. And in deciding on extensions, the court laid down certain norms whereby these could be done. It started giving directions as to sustainable use of forests. It constituted high power committees for northeastern India and for the entire country for faithful implementation of these many orders as was mentioned. It gave clarifications as to what is a minor forest produce and how forest dependent communities who are dependent on these forest produce need have to be protected, their interests be protected, their claims and entitlements for their livelihood purposes are to be met. Very detailed administrative processes that the state agency that should have performed were being taken over, and by way of administrative instructions through the writ mandamusing the states to carry on these activities before the forest conservation becomes a reality. The court did not close the case because the court was concerned that once they decide a case, although the assurance is given by the government, there is no guarantee that implementation of its orders would be done both in its letter and spirit. And so it created what was called as a centrally empowered committee. A new body was created called as CEC to oversee the implementation of its orders. Because we as a court, we pass orders, but we are not there to execute it, we are not there to implement it, we are not there to monitor it. And for doing that, you should have done it. Since you are not doing it as an administration, we are creating a body, a very high powered committee, which will be the eyes and ears of the court, which will ensure the execution of our orders and will take the position of the Supreme Court to that extent so that our burden of dealing with forest cases on a day-to-day basis will be reduced, and they will act on our behalf in dealing with that. This is a very rare thing. In addition to this, the court also created what is called as a forest commission to advise the government from time to time on matters concerning forest conservation and management. This is a very rare thing to have ever occurred in the entire history of not just forest administration, but in the history of governance, because the impression that people had was the courts of law are there only to resolve disputes. And here the court found that administration has not really performed its task, and so it took upon itself the responsibility of giving directions to be implemented by different departments of the government. And for that reason, this particular case is a very important landmark case which fuses both administrative and judicial functions to meet the ends of justice. The court of law assumed for itself and performed as one shining example of a deeper engagement and involvement of the court of law in policy, law, implementation, monitoring, and ensuring that the basic objective of the forest law is achieved. If you take an overall view of this entire Forest Act of 1927 and the Forest Conservation Act of 1980, basically this law is colonial in its content because it talks of centralization of powers. Involving people has not been much of a major feature here. It continues to be worked with very little change, either in the structure or in the scheme of governance here. The role for the center, which actually is a 1980 phenomenon, has further centralized the power of forest administration and governance. Where do you locate the people? What is their status and their position? Do they have anything to do with the forest? Do they have rights or anything like that? Is something which we will be taking up in the third part of our inquiry. In the first two parts, we discussed about the forest law and the forest conservation law, the first two aspects of this module. In the third module, we are going to begin the people into the whole scheme of things in forest management. And how did that occur? And with what effect is what we are going to see in this third installment of our discussion in this module, which is devoted for a discussion on forest rights and something that is described as CAMPA.